try to do a few things to undermine California's medical marijuana laws. Well, one thing that it did was it convened a commission. It convened the very prestigious National Institute of Medicine Commission to study whether marijuana had medical use. And the commission met for several years, and in 1999 issued its conclusions, where it concluded that marijuana clearly has medical use for a number of symptoms, and recommended effectively that the government kind of take another look at its stance on medical marijuana. Of course, the pattern was the same. The White House decided it would simply ignore the commission's recommendations, which leads us to the other way that the federal government attempted to undermine California's medical marijuana laws. In California, no matter how dire your medical need is, it's only legal for you to possess or cultivate marijuana if you have a doctor's recommendation. So you could be an AIDS patient suffering from AIDS wasting syndrome. You have a legitimate medical need, but it's only legal if you have a doctor's recommendation. So what the federal government did was, as the law was enacted, it threatened to revoke the DEA licenses of any doctor who was willing to recommend marijuana to a patient. It would rip the heart right out of California's medical marijuana laws, because a DEA license is what allows a doctor to prescribe substances. If you can't write prescriptions, you're not going to get a lot of business as a doctor. So this was a very serious threat. And so what happened was, as a group of physicians, along with the ACLU and some other groups, took the federal government to federal court and obtained an injunction against the federal government. The federal court found, in this case, was affirmed in the Ninth Circuit and is now affirmed the injunction on the basis that there's a First Amendment right for a physician to discuss treatment options with the patients, and enjoined the federal government from continuing to harass doctors for recommending marijuana to their patients. The feds also had help in trying to undermine California's medical marijuana laws, unfortunately, from our own people. There are a number of what we refer to as rogue law enforcement officers in the state of California. All of the major law enforcement associations, the California Police Chiefs Association, the California Sheriff's Association, and the California Peace Officers Association, all three of them publicly opposed Prop 215 and have continued to act out on their opposition to 215. Some of these rogue law enforcement officers harass patients. They'll stop them at a routine arrest, and they'll ask them, do you have any drugs or alcohol in the car? And when they answer yes, I have an ounce of marijuana because I'm a medical marijuana patient, they would seize that marijuana despite knowing that it was legal, force the patient then to have to go to court to face the criminal charges, which were uniformly dismissed, and then have to file a motion for return of property to get their marijuana back. We successfully have sued both the CHP and the city of Garden Grove, and so now it's settled law that they can't do that anymore. But it demonstrates that even some local law enforcement officers are against this and tried to undermine what was going on. And to this end, the California Police Chiefs Association sent a letter to the DEA, I believe it was in 2006, it may have been 2005, requesting that the DEA come in and continue and to bust these dispensaries. And sometimes they do, and sometimes they don't. As far as we can tell, the pattern is if a local law enforcement agency calls in the DEA to bust a dispensary that is as legitimate as they get. There's a case of a gentleman by the name of Charles Lynch. Charles Lynch did not profit from his sales of marijuana. He is a humanitarian. He was welcomed by the local Chamber of Commerce in Morro Bay, but the sheriff of San Luis Obispo is against what he was doing. And so he called in the feds. The feds came in and they busted Charles Lynch. Charles Lynch was prosecuted despite complying with the Attorney General guidelines, despite being, again, a compassionate person and a humanitarian. And Charles Lynch's sentencing is coming up. Now, I can't blame Mr. Russoniello for this. This is in the Central District. It's a different...
Thank you, Joe.
Yes. It's a different U.S. attorney. But we cannot say that simply being a compassionate person who complies with California law is not going to keep you out of a federal prison The prosecution in that case, I believe, is recommending 5 years. The judge in that case actually asked the prosecution if that changes now that you have the new federal policy, and the U.S. attorney said, no, it doesn't. To which the judge said, well, postpone the sentencing because I want to hear this from the Department of Justice. I'm not satisfied with your response. So we'll find out what happens there. And that's, I guess, where I would ask Mr. Russoniello. We're delighted to see that it appears that the federal government is not going to continue to investigate and prosecute legitimate medical marijuana dispensers. However, that does beg the question of the folks that are already being prosecuted or have already been prosecuted. It's a policy that we certainly welcome, but the prosecutor does have the discretion to dismiss charges in these ongoing prosecutions and even to strike deals in cases where folks have already been prosecuted. And we would certainly ask both this U.S. Attorney's Office as well as every U.S. Attorney's Office that has had these prosecutions already if they'll change their approach under the new regime, because these folks who've been prosecuted actually do have names, they have faith, they have families, and it's a shame to watch them have to go to federal prison. It is true that the Supreme Court, the U.S. Supreme Court, has determined that the federal government has the authority to prosecute medical marijuana patients. Just because what you're doing is compliant with state law, the federal government can, if it so chooses, come in and bust these folks and harass them in other ways. However, in that same case, the Supreme Court at least hinted at the possibility that this wasn't the wisest approach. They said that the federal government has the authority, but that doesn't necessarily make it the wise approach. And what this brings us to is prosecutorial discretion. As we all know, prosecutors have a great amount of discretion. As Mr. Russoniello mentioned, there are limited law enforcement resources, and so it's important to prioritize. Given that, and given that the U.S. Supreme Court affirmed this prosecutorial discretion, and given that the voters of California believe that it's sensible that medical marijuana patients and their caregivers not be criminalized or not have criminal punishments against them, it appears to us to be very wise for the prosecutors in the state, the federal prosecutors, to use their prosecutorial discretion not to go after legitimate medical marijuana patients. I take some solace in Mr. Russoniello's statement. I believe he said that there's a little likelihood that someone will be prosecuted if they comply with state law, but I don't take but so much solace. In a society where we believe that we should know what the law is...
You don't trust me?
Well, no, I certainly trust you that there's a little likelihood, but I guess I would have liked to have heard that there's no likelihood, or simply even a more affirmative statement, we will not prosecute you if you comply with state law, because it still leaves people with a certain amount of doubt, and unfortunately this certain amount of doubt carries with it frequently a 10-year mandatory minimum sentence. So little likelihood gets us, somewhere, but it doesn't get us completely where we need to be.
Wait, a 10-year mandatory minimum?
Yes.
How much marijuana do you have to have for 10 years?
A conspiracy to distribute 100 kilograms or 100, not 100, 1,000 kilograms or more, but I mean, I would guess.
1,000 kilograms is more than personal use, right?
Yeah, but sure. But we're talking about dispensaries,
Okay.
and so I mean, I think it's safe to say that the majority of dispensaries in San Francisco easily would qualify for distributing 1,000 kilograms or more. At best, it would be 100 kilograms, which carries with it a 5-year statutory minimum, which is far more time than I would ever like to serve. And that just leads me, I guess, to the final point. And this is where there's still a lack of clarity what the federal position is. The federal government says it won't prosecute where people effectively are in compliance with state law, or little likely